This is Kenya's biggest conversation. We have a guest in the studio, Advocate Danstan Omari. Before we introduce him, the day's proverb. Now that CT Muga has taken a day off today to just sit and, he has friends in the Supreme Court. And he did not want to be here and give leakage. It may just slip.
This day off was strategic.
He has friends in the Supreme Court. How many?
Say things like this.
4 of the judges of the Supreme Court are CT Muga's personal friends. Hey, so he was like, "Apana today."
No.
This one, let me sit it out. No. Anyway, he's away on a break. The day's proverb is from Namibia. Namibia is a country in the southern part of Africa, and it exports, among other things, live animals, manufactured goods, tungsten, silver, zinc, tin, lead, uranium, and diamonds. In fact, 25% of Namibia's exports, thereabout, diamonds. So the proverb is about diamonds. And Namibians say, a diamond's father is coal, yet it regards itself as upper class. A diamond comes from coal, but no.
Cool.
I'm a diamond. Upper class. I mean, we're different. Yeah, we come from the ground. Yeah, but you see, I'm upper class.
I'm set apart, my friend.
Yes, setting yourself apart. Welcome to our guest, Danstan Omari, Advocate. Good morning, Wakili.
Do I answer in Kiswahili and in English?
In all languages.
In all languages.
Eh.
Sijambo. Good morning, everybody.
There's not that joke of Wakili, a quick one. When you want to seek some advice and you don't want to pay for it, Wakili, a quick one.
Just a quick one.
Just a fast one.
It's just a fast one. What if, suppose I was to, get into a contract and then these people are telling me 1 or 2 things.
I have a friend.
Yeah, I have a friend. What should I advise them? A quick one, Wakili. From your experience, from your friends in the corridors of justice, you practice with them, you have some of them you've gone to school with, some of them you meet in what CT Muga calls cultural establishments. Ukuna leakage ya hii BBI?
The leakage is with everybody. But I have mine very seriously. 1, based on the position of the law. 2, based on the body language of the judges and their philosophy on what they stand on. 3rd, what the country is expecting. So really, everybody has a leakage. The problem is whether the leakage is the real one. Because you can have one, what you think is a leakage.
Yeah.
The results are already out. There's nothing to guess about it. The judgment is ready. It is written. It is only waiting for spies to put it live to the Kenyans. So there's really nothing to anticipate. It is already cast in stone.
In about 45 minutes, the Supreme Court judges will start delivering this judgment. Now, what is before them? I mean, what was taken before the Supreme Court judges?
The Supreme Court judges are dealing with the very many questions that started from the High Court, came to the Court of Appeal. Then the 7 questions were presented before the judges in the Supreme Court. One is a question about whether the IBC had the quorum to deal with the matters as presented at that time. Remember, the IBC was not fully constituted as we have today. 2, whether the president can initiate a popular initiative or the president is barred from dealing with that issue. 3rd, whether Kenya is going to allow the executive to appoint a judicial ombudsman from the executive point of view. 4th, the biggest question is about the basic structure. Do we have some provisions of the Constitution that cannot be amended, that are the pillars, the foundation based that this country cannot touch? Then the other issues are really not issues about the 270 constituencies, whether the IBC has that jurisdiction or Parliament can have the jurisdiction, the question about the referendum and very many others. But the bigger question is, those are legal rigmaroles. The real questions Kenyans are asking is Raila winning? Is Ruto winning? That is what the question is. But as lawyers, we'll be looking at those jargons and everything. The verdict is Kenyans will be waiting to hear spies say BBI dead, reggae is back.
Yeah.
Danstan,
That is all.
you say Kenyans are wondering, even through this BBI appeal process, whether it will be overturned or not, whether Raila is winning or whether Ruto is winning. What does that have to do with anything?
Really, this was a question that was framed for the politics of 2022. The formation and the arithmetic to formation of a BBI was geared towards creating a momentum for political one party to lose and another party to win. At the fulcrum of the BBI, legally, is the legal questions. Politically, is a question about who becomes the next president and whether the president of the Republic of Kenya, the current one, can have a say on who comes to be the next president. So really, it was hidden. It was chameleonic. Now we are dealing with a question as framed for the 9th of August 2022. Is BBI going to pass? Well, if it passes, who will it hurt most? The horses have been defined. There are only two. Who will benefit out of it? Suppose, and I have just been talking here, Kenyans, the two presenters are shocked. Suppose the BBI today, judges say the election is deferred to 2030. What can we do? Where can we go? The decision of the Supreme Court is final. Whether the Supreme Court decision is wrong, whether the Supreme Court decision is right, we have no avenue to challenge that decision. Are we going to get real thunder coming out today, or are we going to get the anticlimax?
Do you think, Danstan, that the 7 judges of the Supreme Court will be sitting and looking at this from that political angle? Understanding the politics of the day, understanding the political implication of whatever they tell us today. Will they be factoring that in, or will they just look at, this is the argument before the court, these are the prayers? There are 7 issues. What do we think about the 7 issues from a legal standpoint? Or will they balance it?
We look at the Supreme Court from 3 angles. One, the Supreme Court is not an ordinary creature. Worldwide, Supreme Courts are not strictly judicial courts. They are not legalistic. The Supreme Courts are supposed to look at other exterior issues. For example, the public interest, the finances that have been put in place, what is the general population wanting for, stabilizing the politics of the day, the morals of the people, the values of the people. So when you look at the Supreme Court, you are looking at a quasi-judicial entity that its role is to keep the fabric of the country together. While you look at the High Court and the Court of Appeal, is strictly the law. Procedures. If you didn't get it, if you didn't file your papers within this time, if it's not provided by the law, that is all. So we are likely to see much of the politics of the day coming out in the judgment of the Supreme Court today.
Okay, so if I'm just going to jump from one peg to the next, Danstan, what you're essentially saying is that politics will be taken into consideration here.
Completely.
Politically, we already know that folks take sides. So if we take it to its logical conclusion, then there's a possibility that the Supreme Court will take a side as opposed to being judicious and impartial in nature, which already seems unfair.
The question before the court is not a legal question. It's a political question. The Supreme Court has only one question that it must take sides: a presidential election. One has lost, one has won.
But based on procedure. Danstan.
Very many issues.
It was based on procedure. And I think that was one of the things they said. The procedure through which this election winner was declared was faulty. It was flawed.
Yes.
Based on that, they made a decision. In this case, you're basically saying you're taking the political atmosphere into consideration and you're going to make a decision based on that. You almost have no choice but to be biased.
In 2017, in 2013, in Raila 1, 2013, Raila 2, 2017, Raila 3, 2017, there was only one question: who is the winner? In the BBI question, there are 7 to 10 questions. So the Supreme Court has the leeway to give you 3, give you 4. To
Sorry,
balance that.
Let me come back to that. 2017. The Supreme Court did not dispute the winner of the election.
Yes.
The Supreme Court had an issue with the flawed procedure
Yes.
as to the transmission of results. They did not come and say Uhuru Kenyatta did not win the election. They did not say he's not the winner. They said there was a problem with procedure,
All right.
and that problem could be traced, right? Here, we're talking, like you said, on issues morality, politics, which is all subjective. So it would, again, I'm just going back and I'm trying to, if you have not noticed,
I've noticed.
get you to say clearly, are you essentially saying that there's the possibility here that the Supreme Court could be biased in its ruling because of the fact that it's dealing with politics and trying to keep the country tied together in peace?
If we look at the Supreme Court from the eyes of a legalistic approach, then we'll think that it will be biased. If we look at the Supreme Court and look at the jurisprudence for the creation of the Supreme Court, the object behind the creation of the Supreme Court is to ensure that this country does not collapse. That is not different. That's totally different from the structure and objectives of the Court of Appeal and the lower court. So in essence, they will look at procedure out of one argument, kill one argument, or grant one argument based on procedure. They will look at another argument, use the parameter of politics, kill it or grant it. They look another argument and say the churches and the religious guys need to be appeased also. Get that as a parameter, get somebody losing and somebody. So because of the variety available, the options available are 7 or 10, they will use all the parameters for everybody to work with a win-win situation. If the Supreme Court today decides with finality that the BBI is dead, we are talking of 49.99% of the people in Azimio getting dissatisfied, and the William Ruto team either 51.001. If it is the opposite, it is the same thing. This country needs healing. And the healing that is likely to be, it will be a very subjective type of judgment that will be able to keep
To like
tempers,
appease both sides?
to appease both sides.
Why should they do that though, Danstan? I mean,
That-
look. First of all, is it really likely to be that if the judges say BBI as was presented is good enough to go, it should go to a referendum, that there is likely to be a loser? I don't see it.
The loser in this
This
matter,
thing of saying that, William Ruto will be the one out who, if we go to a referendum, then William Ruto loses. I don't see it.
what I'm
These
saying,
two camps stand to gain
yes,
if BBI goes to referendum.
very well.
None of them stands to lose, really, if it goes to the referendum.
Remember,
It could be an issue of a bruising on the part of Raila Odinga because he came out openly to advocate for BBI. And William Ruto sat on the fence, only coming out at the end of a judgment by the Court of Appeal to say, Mungu anapenda hii Kenya sana. But before that, William Ruto has not said, I do not want BBI.
there are only two guys that we think are in the Supreme Court. There are more than other players in the Supreme Court, but they are not parties registered in the Supreme Court. For example, the church. It is part of the Supreme Court, but nobody has filed their papers to represent the church too. The judiciary itself is a party in this matter. The fact that we have the judiciary ombudsman as a question to be decided, the judiciary, the 7 judges are parties in this case, but they are not formally a party in this matter. So that's why I've said, when you make a judgment of such a magnitude on very many questions, it is wisdom and it is the way you handle it that matters. The judges have a fundamental opportunity, the Solomonic opportunity today, either to move with the country or to move with that 49% of the country. That is the question. Unlike in presidential decisions where there will be only one winner. Here, but the judges might decide, we don't
Why
care.
can't there be one winner here?
Well, we don't care. We throw out the BBI or we grant the BBI. What will be the repercussions? And that, to me, is what is more important than the decision they come about.
Directly then, what would be the repercussions? If they throw out the BBI, what will be the political repercussions of that?
If they throw out the BBI, both of the political formations will lose heavily and gain heavily. One, the politicians as chameleons will turn out that if it has been thrown out, then William Ruto's team will be saying, we told you. We know the law. Then Baba will turn with his Azimio and say, you see, these people had not having any intention, good intention for this country. Both sides, the story sells. If they uphold the decision, William Ruto will be saying, these people have created positions for themselves, but give us power. When we take power, we will not implement this. While Baba will be saying, we told you, this is the spirit and this is the way. It is only me who knows how to implement this. So the politicians will still carry the day, whichever decision that comes out.
So there's no loser.
Politicians, there will be no loser. What will be the loser is the country. And that is why the judiciary will be looking at how do they look at the interest of Wanjiku within this decision.
How does the country lose?
The country loses, for example, on one, I'm a lawyer, and a serious lawyer for that matter.
Of course.
Can we have an executive appointing the ombudsman? Who is likely to lose? It's not the judiciary. It is the Kenyans. Two, is it really a good story, for example, the amount of money going to the counties to be stopped? Because of two guys fighting. The judges must come and say, really, we cannot stop money being taken to my constituents in Nyamira. Let the money go. So the judges must look outside the political shenanigans of Raila Odinga and William Ruto and see what benefits Kenyans and grant that which benefits Kenyans.
Is it possible to do so in the political dispensation that we're currently existing in? Is it possible to do so outside of those two individuals? Because it would seem as though everything has been gobbled up by what one side is saying and what the other side is saying, which comes to the other point and saying it cannot be but a competition. The only reason why this has come to the Supreme Court is because there was dissatisfaction on one side and said, look, we wanted it to be this way. You've said no. We're going to the highest court in the land to say, come on, can you then rule on this? Is it possible to do anything, even as that apex court, void of these two political figures right now, the way things are currently?
The judges know very well. Those judges will know them. And they know very well that the decision they make is beyond the lifespan of William Ruto and Raila Odinga.
Okay.
It is also beyond the decision of the lifespan of these 7 judges. It is about the decision of this country, which has been there since creation and which will be there to the end of the world. So the decision they are making is not a decision that pleases Raila Odinga or pleases William Ruto. Is a decision about Wanjiku, and Wanjiku will be there for millions of years. The political formations that are there today are just temporal vehicles, and they are specific with selfish interest at heart. So the judges must look beyond the politics of today, appease them with one cake, and give the other one with a samosa, but deal with the question of the prosperity and livelihood and future of this nation. That is why I said the judges will be wearing specs that are not limited to 2022 elections, but to the future of this nation.
Indeed.
Suppose, like you say, that they come up with, out of the 7 questions, they say 4, they disagree on 4 with the lower court, the Court of Appeal, but they agree on 3 with the Court of Appeal. Say they agree with the Court of Appeal that the president can be sued. They agree with the Court of Appeal that IEBC is the only one to determine the constituencies. They agree with the Court of Appeal that the ombudsman should not come from the executive.
Yes.
But they disagree with the Court of Appeal and say there is no basic structure in Kenya's constitution. They say the other issues that are before them, which are talking about the basic structure and the others that are political questions. Can we then head to a referendum with the same document as it is, or does it have to be rewritten?
In the judgment of such magnitude, the Supreme Court before this judgment is clothed with one jurisdiction, provision of advisory. Whenever there is a problem that the law cannot provide, the Supreme Court can provide an advisory. That advisory can be a procedural advisory, providing that these are the steps. If you want to do a referendum, this is what is to be done. The timelines are there. I expect within the judgment, those questions, those lacuna in the Elections Act, those lacuna in the statutory acts that don't have them, the Supreme Court now with finality will be providing the roadmap to a referendum. It will provide a roadmap to the creation of extra constituencies. It will provide a roadmap to the question of the gender question. How do we achieve the gender question? So it is not only the decision that BBI has won, but as lawyers, we are looking at what now the guidelines will be and what Parliament is likely to be ordered to do to breathe to life the judgment that is coming out today.
Is there a judgment that can come out of the Supreme Court that would completely render this particular BBI bill dead? For example, if they say that the president cannot initiate a referendum, a constitutional amendment process, if they say that, can we continue with this particular BBI bill?
There has been a new type of jurisprudence that started 2 years ago, where courts are finding that something is unconstitutional or something is illegal, but they give the government 3 days or 3 months or 1 year to regularize. A very good example is the NMS question.
Yep.
The court found out that the entity, the way it came, was illegal, but they were told, for the sake of the country, we are not going to declare NMS illegal now. Go and regularize this matter. So the Supreme Court, being alive to the reality that straight jacket judgment where you say this is illegal, regardless of the effort that has been done is counterproductive. So the Supreme Court might make a judgment, make a finding that the president did not have the legal capacity to do that. But there's a new term, judges, when you hear as the court say, however, when that has been said, then the judges are diverting from what they have found out, but they are giving a breathing space, the oxygen principle that, however, do this and this for this purpose, for the sake of the country. We expect the Supreme Court to take that direction.
Let's take a break. 28 minutes to 9. Kenya's biggest conversation, the Situation Room. Where will the chips fall when the BBI is before the Supreme Court judges when they deliver their judgment? Is it a ruling or a judgment?
Judgment.
It's a judgment. The
Finality.
judgment of the Supreme Court this morning. It starts at 9 o'clock at the Supreme Court. Where will the chips fall? Lawyer Danstan Omari is here with us and we're discussing that. We'll be back shortly after this quick break.
This is the Situation Room.
Lawyer Danstan Omari is with us in the studio. This morning it's Eric and Ndu. CT is away. We are talking about the likely outcome from the Supreme Court this morning when the judges troop into the court and they deliver the judgment on this BBI case. Lawyer Omari says, they've got to balance this thing. They have got to give everybody and make everybody feel like, they went to court and they came out with something. So they are likely to say, in some cases, we agree with a court of appeal. In some cases, we disagree with the court of appeal. In some cases, they say, all right, this is a way out for this particular quagmire. But I want to come back to that question. Is there no judgment that can come out of the court today that actually renders this bill as currently drafted impossible to go to a referendum?
There can be. Remember, we are only talking of more Kenyans that we are speculating. the judges can decide to throw away everything. But the question that will be there is for whose benefit? Article 259 provides for how to interpret constitutional questions. That the article provides that in matters constitutional, try to be purposeful. Will that judgment of granting absolutely everything or throwing everything out be a proper interpretation of Article 259 that give to effect the purpose, the spirit, the interest of Kenyans? But the judges are not bound by our feelings. Remember, the judges are not bound by anybody's arguments or anybody's emotional or political subjectivity. The judges can decide that the law must be followed as the law is and find out that this is wrong, throw it out. This is right, throw it out. We'll only remain to discuss the further implication when we teach at the law school what the judgment is all about.
Is it not likely also that the judges could look at the general, like you said, public interest? This constitution has one owner, and that is the citizen of Kenya, we the people. So look at it and see what is likely to be in the best interest of the owner of the constitution at this particular case, and say throw away everything. Throwing away everything protects the constitution at this particular point, takes everybody back to the drawing board, opens up the conversation. Are you ready to amend your constitution as a Kenyan? And what route do you want to use in amending that constitution? And by so doing, they also set that jurisprudence of this is a route to take in when you want to amend a constitution. You agree that there's a basic principle. You agree if it's a popular initiative, this is how it starts and this is how it ends. If it's a parliamentary initiative, this is how you go. You agree on the role of the IEBC in this process. All those things.
The judges know the pressure that they have been put into. Let me tell you, these guys have not been sleeping. From the day the animal moved from the lower court, it came to the Court of Appeal, the judges at the Supreme Court were saying, oh my God, I hope nobody appeals to this matter.
Yeah.
History for millions of years, my decision will be quoted or criticized.
Yep.
The judges, knowing that burden, might decide to play the best game ever that no team in the Premier League has ever played. Say, we do not own this constitution. On the 9th of August, put all these questions to the owners. Increase the ballot from 6 to 7. Put the question of a referendum. Let the Kenyans decide. Because this is not a legal question. This is not a judge's question. As we have said, go to the referendum and deal with it. That will be the masterstroke. And that one, I'm very definite that the judges are going to use that approach and say, okay, but we will provide the guidelines on what is supposed to be incorporated before that question is presented to the referendum. So that is the likely scenario that Kenyans brave for a question of the referendum on this.
A seventh ballot.
If there are timelines that cannot be met, for example, some guidelines that need to be implemented for ukarabati fanywe kwa BBI for the referendum, and that is why I said the judges might say, we have done it fast. We moved the election of 2013 from August to December, and the argument was school calendar. Let us push these elections to December to allow students do their exam, and also the BBI proponents incorporate these arguments, and that now goes to Parliament, for Parliament to pass it, then it goes to a referendum. So there's a possibility that the judges might, one, stop the elections of 9th, but order for a referendum and give a new date that will incorporate a proper referendum that meets what the guidelines or what the threshold that they'll put in.
Okay. What repercussions would we be looking at? Circumstantial, because since we're coloring within the lines of speculation here, and if that would happen, what would it look like? Because essentially what you're telling the people, if that would be the judgment, which is final, what you're telling the people is, all right, all this talk that we've had for the last 1.5 years, now you decide whether you want these changes to take place in the constitution that is yours. What would be the repercussions of such?
The winner will be the Kenyan. Because the Kenyan has been told, this is your document. Give us how you want us to govern you. That cannot be us. Give us whether you want a judiciary ombudsman appointed by the executive. It is you. The judiciary does not belong to the judiciary. It belongs to the Kenyans. Remember, Article 2 creates at the preamble of the Constitution under Article 1, we the people are the sovereign. Tell us how the sovereign you want us to be governed. That is likely to be the only escape route for the judiciary to avoid the backlash. Remember what happened in 2013 when Raila Odinga's affidavit, Justice the Mutunga and the others rejected. To date, that question, the Supreme Court has never come out of it. I suppose you allowed that affidavit. Could the decision be the same way? So I'm saying the judiciary is saying these questions are weighty. These questions, you people decide. And definitely we are going to have a referendum and the people decide. To me, what I'm not sure is which date that referendum will be. Will it be in August or will it be in July? But the final decider will not be the judiciary. Even if they give 4 to 3,
They will throw that thing back.
they will
to the
throw
people.
it back to the citizens. For me, you know, my decision, even if I'm one, I need to be heard. Article 10 of the Constitution, we need to be heard.
Remind me, Danstan, what came out of the previous application on the number of questions in the referendum in this particular case?
The questions were very many.
I'm speaking about the specific application, whether because you're seeking to amend the constitution in 72 or 70 what different ways,
Yes.
should you have 74 different ways,
Yes,
different questions at the referendum, or should it just be one, yes or no, that you accept everything and or reject everything?
The question that was presented by the two parties is one, there's the people of Raila Odinga and team were saying, you only need one question, yes or no. The other side is saying there are more than 72 questions of amendments of articles. We need to vote for each and item that is there. The Supreme Court, that must be decided by them, whether they like it or not. They cannot run away. If they are saying every question should be put as a question to the voters, then we have 6 elective posts and 72 questions
On
to
the
be
referendum.
on the referendum. So the people are asking if the question there is, should lawyers wear wigs? It must be there.
Yes or no?
On a ballot, Danstan.
That's what I'm saying. If they agree that each question needs the Kenyans' input, then that will be in the ballot. Is it logistically possible?
Oh, come on.
It can't. Will they say each referendum will only have one question? Reduce the BBI to only one question, or deal with one question, so that we have 72 referendums spread in the next 30 years. For each question, a referendum of its own.
To amend the
I
Constitution.
think it is going to be a serious question that definitely the judges have got to provide leadership.
Not all the 72 questions, though, require a referendum.
They are those administrative.
Yeah.
The Supreme Court can say matters specific to a referendum, we have identified there are 4. Only 4 questions. Others are administrative questions. You go to Parliament, deal with them, take them to the cabinet, draft policies and deal with that. So the Supreme Court is going to bring out bear. And that's why I said they will have to provide a roadmap on every issue, the nitty-gritty. But the term, however, they can say we have identified 10 constitutional questions for the referendum. You have been given 2 weeks. Rephrase them through a mutual agreement. Remember, William was saying we were never consulted. Baba is saying we consulted you. You refused. We don't need you. The Supreme Court can order for a constituent assembly to be constituted at Kasarani Stadium within 2 days for them to raise only one question to be in the ballot.
But Danstan, here we are talking about petitioners who raised an issue, right, against the constitution of the BBI itself. We are not looking at a political competition here. So who would come together to the table to say essentially, here, come and fix this thing? Who would come together here? The petitioners and the BBI secretariat?
The people of Kenya.
The people of Kenya, represented by whom?
If the leaders cannot provide leadership the way they have never provided, they pretend that they provide leadership on my behalf when they are selfishly moving their own agenda, the Supreme Court can decide that the threshold to be met for a referendum question is this.
Yeah.
If there is no participation on both sides, that question can go to a referendum. That's why I said, if at the time when I was looking at the appointment of the popes in Vatican, you are told get into that room. Don't come out, no food, no water, until there is white smoke. The Supreme Court can put parameters that will outfox these political protagonists for the sake of the country. Or it can defer that question to when the two people are not there. So really these are the medical practitioners we are expecting today to give us the treatment of the patient who is either dying today or will be alive. But the judges will not allow Kenyans to die today.
They could tell us they're the mortician.
They will. No. Kenyans, not morticians.
Patient arrived at our depot already dead.
No. The Supreme Court will revive the patient.
On the issue of a constituent assembly, though, and I mean, that has always been my argument, first of all, that this process needed to get to a point. Yashpal Guy taught us
Yes.
that the people make a constitution and then they sit and discuss amongst themselves as the people and they agree on what goes to the referendum. If the judges said, all right, so take a step back, take several steps back, make this a popular initiative, make it a popular initiative, and because there are very many amendments, have a constituent assembly, how would that happen? Would we say that forget everything? Okay, you can use that as a reference document. What came out of the BBI task force is just a reference document, but then you're starting the process afresh, where you're saying that this is how we are going to amend our constitution as a people. Maybe Dennis Wawero and Junet Mohammed, who call themselves the promoters of this amendment, say, we are calling on Kenyans to come together so that we can go to Bomas and have this conversation for a week.
That is a possibility to bring down the temperatures that are there. If the judges are going to say the final decider is a referendum and put a rider that referendum can only be done if this document is subjected to a constituent assembly, the proponents and opponents will be forced into the negotiating table. Already now, one, Raila Odinga was using it to bar William Ruto from even appearing near the ballot of 2022. William Ruto was opposing it to ensure that Baba does not even at all get the mileage. Today, the two coalitions, the people, William Ruto and Baba, have gone through parliament. They have created.
Isn't it unfortunate, though, that we're looking at this judicial process and we're calling it a political one? That it has become political, and then we're now saying that two sides are sparring. Meanwhile, we're looking at fundamental issues that deal with the constitutionality of the nation. Those are the issues that we're talking about. The increment of constituencies around the country, a judiciary ombudsman. We are talking about whether the president can actually come and change things. But here we are, and we've turned it into a political conversation, two sides being pitted against another.
The sadness, and this is the sadness, it is only the politics it's politics that deliver constitutions. It is politics that delivers the law. It's politics that delivers the economy. Everything is politics. The only problem Kenyans we have is that we do not see proper politics for the benefit of this country. And that is why I'm saying constitutional making process is a political process that is governed and moved by the citizens. Legal processes is a constitutional process that emanates from a member of parliament being elected to go to parliament to make a law, and we use it in court. We cannot completely move away from the political agenda. And one of the questions before the judges today is, what is the role of the head of politics, the head of state?
Yeah.
President Uhuru Kenyatta is the substantive head of politics in this country, hidden in the term head of state. You become a head of state virtually by virtue of political activism. So in my own view, the judges are likely to compel a constituent process governed either by an entity created by the judges to deal with the questions and say, submit to this organ your proposals within 2 weeks. Let us have it managed this process, because courts worldwide have powers to supervise their judgments. Because it will be academic for them to give a judgment that cannot be implemented. As I've said, these judges want to leave a legacy. When their death, 100 years to come, they will be remembered as people who brought the good of the country first. But
there's also legal jurisprudence here.
the legal jurisprudence is also going to be brought
For
up
instance, if they, for example, say that there is no basic structure in this constitution, that stands for a very long time.
yes,
If they say there is basic structure in the constitution, it stands for a very long time. So they've got to, here they can't look at the politics of Baba and William. They've got to look at what exactly are we saying going forward with regards to a constitution that belongs to the people of Kenya. Does it have a basic structure, or does it not have a basic structure? And they will be quoted not just in the country, but entire Commonwealth and the world.
this question about the basic structure, they have got to look at the basic structure concept in relation to the 5th and 100 generations to come. The decision of the Supreme Court cannot be challenged anywhere. It can only be quoted in other jurisdictions. The Kenyan courts are bound by it. You cannot deal with the decision of the Supreme Court. So that is why the judges will have to think, how do they navigate that question? It is not a simple matter that you easily say, you are right, you are wrong. It is a decision that is going to be there a million years. One question. If you say there is no basic structure, or if you say you cannot amend these things, then they will have to say there exists a basic structure, but create a way to amend it. Because the generations that are coming 100 years, they are going to be different generations that will not be respecting the value systems that we have today. If we are blocking that they cannot amend, they must live the way we are living today, those guys will revolt and carry guns, because once the law becomes so rigid,
They'll overthrow the law.
they'll overthrow the law.
As we conclude, Wakili, is there a likelihood that the outcome of today's judgment is actually going to shield these 7 judges from politics? From looking at them and saying, aha, this
Look at
is
what
how
you did.
Joe Kindongo voted on this particular matter. And we all know. Is it possible for us to not actually look at them that way and just see that these are judges? They are looking at what is presented before them and considering what's in the best interest of the country.
Supreme Court judges worldwide are not appointed competitively the way we do here. That you apply for a job, it is advertised, you go for interview, you get a job. Supreme Court judges are appointed based on their known philosophy. They are either conservatives or they are liberals. So that is why in the US and all over, already people know, they count how many judges are there. Those are conservatives, 4. Those are 3. We've lost. This jurisprudence is developing. If today the 7 judges sit there, Kenyans will tell you, here, ile kabila yake ni, ule anatoka wapi, jina yake ni nani, ule ameolewa wapi. So that can never go away. And the 7 judges, I'm told they are watching this and listening to this very critically, should not fear that stigma. It will be there. They will be called names. They will be told what they have done. They'll be told they have been bribed. But I am urging the judges to forget about those because they'll not stop it. Even if they come and ask, like Pilato said, Kenyans, what do you want? Our judgment is here. This guy is innocent. What do you want? No. We want him free. Jesus to be sacrificed. Still, those judges were blamed. So we expect the 7 judges to stand with the rule of law, to stand firm and stand their judgment for the sake of this country.
Asante sana. Lawyer Danstan Omari, advocate of the High Court of Kenya, he's been here this morning just doing a quick one, our Kili, a quick one on the matter that's before the Supreme Court. Thank you very much for joining us. Join us again next time.